What's up, guys? So, I am going to wait 2 or 3 minutes, talk to you guys about kind of what's going on, because I want to see if this gets blocked again, or the connection gets blocked again. I updated my phone. Took about an hour, not as long as I thought. I could run on Wi-Fi, but my Wi-Fi it's not as fast as the network usually, and it will definitely be laggy then, and possibly may not work as well. But I have it off Wi-Fi and I'm on network now, so basically the reason I'm waiting here is because every time I've come on and talked and I've started reading these regulations, this happens. My connection goes away. Or, that's happened today. Last night, I got a barrage of about 30 phone calls from blocked numbers and my own number. I called Verizon customer service and they did what they could do to take care of it. And then, of course, wanted me to download a caller ID app sort of thing, and I was like, you know what, I'm not going to mess with that. I haven't had that problem since, but now I'm having the problem. It was fine until I started sharing to a bunch of groups. Maybe that's it. Maybe it's because I'm sharing it and reading it. Well, I'm going to start sharing it here in a minute, and hopefully we can get through this, and everybody can get through this with me, and will not have a problem with connectivity. I just think it's odd that every time I start reading the regulations, I lose connectivity or I get bombarded by phone calls from blocked numbers. It's like someone's purposely trying to stop me from reading the regulations. Interesting. So, I'd be more than happy to share it for you so we don't have to mess with your feed. I'm going to try this one more time, Tracy. And if we're having issues, then we'll know that may be the culprit. Or, who knows. I'm going to go ahead and try this one last time. And if we have issues, then we'll do it that way, Tracy. Oh, what a pain. Anyway. What up, Jason? What up, Keith? So, Jason, if you didn't happen to catch, I have been getting blocked every time I try to read the regulations and share. I have been losing connectivity while I'm trying to read. And then, last night, got bombarded by blocked phone calls, and then my own number was calling me. Which I talked to Verizon, and I guess they dealt with. I know, right? What the fuck? That's exactly what I said. So, we're going to try it again. I'm about to get into it now. I've got one more place to share it. Okay. So, we'll hop over here. And what I'm going to do is, since I literally got like 2 paragraphs in earlier, I'm going to start with section 6 where we were earlier and go from there. That's on page 30 for those of you that are following along. Page 30, section 6, line 16, section 8006 of title 63. So we're going to start there here momentarily. I have my lemonade in the freezer. I'm going to pop this open, and hopefully it doesn't spew everywhere. I don't think it's frozen solid, but I could be wrong. Oh yeah. Oh yeah. So much for planning ahead and putting it in the freezer. So this is good news. So far, everything we've read is good news. I have some concerns about the caregiver aspect. And once I'm done going through all these videos and going through all this reading, I will talk about that in more detail. But honestly, any other regulations I've seen, I'm 2 pages in and I've found 10 things that I don't like. I've read 30 pages and I found one thing I'm questioning but not necessarily don't like. So overall, absolutely, hell yes, this is the best set we've seen by far. And if any of you guys, oh yeah, that's gonna be nice. All right, we ready? You are welcome, Jason. You and your entire team that was working on this. Okay. Section 6, new law. This is page 30, line 16. Section 8006 of Title 63. A. The authority in conjunction with the department shall employ an executive director and other personnel as necessary to assist the board in carrying out its duties. The executive director shall devote his or her full time to the duties of the office and shall not hold any other offices or employment. B. The department shall not employ any individual if any of the following circumstances exist. 1. The authority shall not employ an individual who has a direct or indirect interest in a licensed medical marijuana business. 2. The individual or his or her spouse, parent, child, spouse, sibling or spouse of a sibling has an application for a license pending before the department or is a member of the board of directors of or an individual financially interested in any licensee or medical marijuana board. Basically, this person cannot have any connection to the medical marijuana business or a license holder in any way, shape, or form. It looks like, even in-laws, which is a good thing. We don't want conflict of interest there. C. The executive director and each key employee, as determined by the authority or department, shall file with the governor a financial disclosure statement listing all assets and liabilities, property and business interests, and sources of income of the member, executive director and key employee, and his or her spouse, if any, affirming that the member, executive director, and key employee are in compliance with this act. The financial disclosure statement shall be made under oath and filed at the time of employment and annually thereafter. D. The executive director shall have been a qualified elector of the state for at least 5 years prior to employment in this position, shall be at least 35, and cannot have been convicted of a felony. The executive director may be removed by the authority for cause after notice and hearing. A successor to an executive director who dies, resigns, or is moved from office shall be hired in the same manner as provided in this section. E. The executive director shall prepare in writing a manual of all employed positions for the authority, including but not limited to job classifications, seniority status, personnel qualifications, duties, maximum and minimum salary schedules, and other personal information as approved by the board. The executive director may select, appoint, and employ such accountants, attorneys, auditors, inspectors, examiners, clerks, secretaries, and other personnel as the executive director deems necessary for the proper administration of the authority and any other statutory duties of the executive director. Oh, that sounds like fun. I do not envy that person. F. All officers and employees of the authority shall be in the exempt unclassified service as provided for in Section 840-5.5 of Title 74 of Oklahoma statutes. Officers and employees of the authority shall not be terminable except for cause as defined by the board. The executive director may delegate to any officer or employee of the authority any of the powers of the executive director and may designate any officer or employee of the authority to perform any of the duties of the executive director. Basically, he can tell anybody to do anything in his name. H. The executive director and all other personnel shall, before entering upon discharge of their duties, can take and subscribe to the oath of office required of state officers as provided by Section 36.2 of Title 51 of Oklahoma statutes. I. The executive director shall adopt an appropriate seal as the seal of Oklahoma Medical Marijuana Authority. J. Every certificate assignment and conveyance executed by the executive director in pursuance of the authority conferred upon the executive director by law and sealed with the seal of authority shall be received in evidence and recorded in the proper recording offices in the same manner as a deed regularly acknowledged as required by law. K. The executive director shall be authorized to suggest rules and regulations governing the oversight and implementation of this act. I. Duties of the executive director. Well, we're at I. We haven't even hit the duties yet. I'm sorry, that's not I. I'm not looking close enough. L. K. L. Duties of executive director. 1. The department may delegate an act required to be performed by the department related to the day-to-day operation of the authority to the executive director. 2. The executive director may authorize authority employees to perform tasks delegated from the department. M. The authority is hereby enabled to create employment positions necessary for the implementation of its obligations pursuant to this act, including but not limited to authority investigators and a senior director of enforcement. The authority, the senior director of enforcement, the executive director, and the department investigators shall have all the powers of any peace officers too. Okay, so we're giving the authority the same power as police officers, but only in relevance to medical marijuana commercially or by a patient, correct? I would assume. I'm sure that's covered in here. Yeah, there we go. Implementation of its obligations pursuant to this act. So, perfect. 1. Investigate violations or suspected violations of this act and any rules promulgated pursuant to it. 2. Serve all warrants, summonses, subpoenas, administrative citations, notices, or other processes related to the enforcement of laws regulating medical marijuana concentrate and medical marijuana product. So basically, these are answering all my questions of what their power is. 3. Assist or aid any law enforcement officer in the performance of his or her duties upon such law enforcement officer's request or the request of other local officials having jurisdiction. 4. Require any business licensee upon 24 hours notice or upon a showing of probable cause to permit an inspection or license premises during business hours or at any time of apparent operation. Marijuana equipment and marijuana accessories or books and records, and to permit the testing of or examination of medical marijuana concentrate or product. 24 hours. I like that because I was noticing in some of the other regs that they were just like they could come in at any point, and although I understand the reason for that, giving 24 hours notice I think is better, because then, business owners already have so much going through their head and having to deal with, and then to have to deal with a random visit. I like the 24 hours. I think that's good. Whoever came up with that, big props. It's probably Jason. 5. Require applicants to submit complete and current applications information required by this act, and fees and approved material changes made by the applicant or license. N. Authority employees shall maintain the confidentiality of all records and information. O. Pursuant to this act, disclosure of confidential records or information in violation of the provisions of this act constitutes a Class 1 misdemeanor. Section 7, new law. Okay, so I know we just got into this, and I am taking just a very quick break here. I'm going to stay with you guys, but I'm glad I got this shared. I got my phone updated, and look, I shouldn't say anything, but I've been on here for a few minutes now, and I'm still going with no interruptions. Of course, as soon as I say something, something will happen, I'm sure. So basically, I'm liking everything I'm seeing so far. I saw somebody had some concerns about some growing restriction. I couldn't read the entire comment, but once I get done and I've gone through all this, I'll go through and look at all the concerns, because I know they're kind of few and far between, and then I'll do one quick wrap-up video that talks about that. And then, of course, make your public comments on the New Health Solutions website if they're still allowing that. I believe they are. Not 100%. I know they were accepting public comments the last time I checked. But yeah, that's the place if you have any sort of concerns. Okay. Moving on. Section 7, new law. A new section of law to be codified in the Oklahoma Statutes, Section 8007, Title 63. A. There is hereby created the Oklahoma Medical Marijuana Authority Fund for the purposes set forth in this section. Okay, the money by the Medical Marijuana Authority. And by the way, guys, we've read lots of pages here, and all we've covered so far, 34 pages, all we've covered so far is glossary, 144 pages of glossary, I might add, and basically, when still going through what the Medical Marijuana Agency is supposed to do. We haven't even got into the permit side of things yet for both commercial or home, which is, or for patient, which is probably the place that we will want to look the closest. But that being said, we'll just go ahead and continue to wade through this. All right, Section 7, new law. This is on page 33, line 22, 8007-63. A. There is hereby created the Oklahoma Medical Marijuana Authority Fund for the purposes set forth in this section. B. The state treasurer shall credit to this fund 1. All money received from applications, reapplications, registration, or licensure as a qualifying patient, caregiver, medical marijuana business, research facility, and education facilities, as well as occupational licenses. 2. All penalties and fines assessed for violations of this act. 3. All money from any other source, whether public or private, designated by this act for deposit into or credited to the Oklahoma Medical Marijuana Authority funds. And 4. Interest earned or other investment income on balance in the Oklahoma Medical Marijuana Authority Fund. C. The fund shall be a continuing fund not subject to fiscal year limitations and shall consist of the proceeds of sales tax levy and the fees and fines of the Oklahoma Medical Marijuana Authority Fund provided for in this act and state question number 788, and any monies or assets contributed to this fund from any other source, public or private. D. Oh, quick little typo there, guys. D's up against the margin. D. The tax on retail medical marijuana sales shall be established at 7% of the gross amount received by the seller. Well, that's more than reasonable, I think. E. The tax shall be collected at the point of sale. Tax proceeds shall be applied primarily to finance the Oklahoma Medical Marijuana Authority. Wasn't 7 what was actually specifically said in 788? I believe it was. F. If proceeds from the levy authorized by subsection A of this section exceed the budgeted amount for running the regulatory and licensing affairs of the medical marijuana program, any surplus shall be apportioned, with 75% going to the general revenue fund and may only be expended for common education. 25% shall be apportioned to the Oklahoma State Department of Mental Health and Substance Abuse Services for distribution and support of drug and alcohol abuse prevention programs. Perfect. G. The Oklahoma Tax Commission shall promulgate rules to administer the provisions of this section. H. The Oklahoma Medical Marijuana Authority funds may be used for expenses of the Oklahoma Medical Marijuana Authority and the Oklahoma State Department of Health to administer their obligations under this act. Wow, the money section. Probably the shortest section so far. That's surprising, but very well written. Section 8, new law, new section of law to be codified in the Oklahoma Statutes, 8008, Title 63. We're on page 35 now. A, the department shall address issues related to the medical marijuana program in Oklahoma, including but not limited to monitoring and disciplinary actions as they relate to the medical marijuana program. Yes, 7% is the perfect amount. B, The department or its designee may perform on-site assessments of a licensee or applicant for any medical marijuana business license issued pursuant to this act to determine compliance with this act or submissions made pursuant to this section. The department may enter the licensed premises of a licensee or applicant to assess or monitor compliance. Let's see how many different ways we can put license in a paragraph. I know, guys, legal speak. 1. Inspections are limited to twice per calendar year, and 24 hours of notice shall be provided to an MMB applicant or licensee prior to an on-site assessment. However, additional inspections may occur when the department, upon a showing of probable cause, shows that an additional inspection is necessary due to violation of this act. Such inspection may be without notice if there is probable cause to believe that such notice will result in the destruction of evidence. That all seems pretty straightforward. It does look like they, would be allowed to come in if they thought that evidence was going to be destroyed, which, you give some, you take some, so I'm not too worried about that. 2. The department may review relevant records of a licensed MMB, research facility, or education facility, and may require and conduct interviews with such persons or entities and persons affiliated with such entities for the purpose of determining compliance with department requirements and applicable laws. However, prior to conducting any interviews with the MMB shall be afforded sufficient time to secure legal counsel representation during such questioning if requested by the MMB or its agents or employees or contractors. Well, that's good. 3. A licensed MMB research facility or education facility shall provide the department or the designee of the department reasonable access to any material and information necessary for determining compliance with this section. 4. Failure by a licensed MMB research facility or education facility to provide the department reasonable access to the premises or materials may result in disciplinary action in accordance with this section. 5. Any failure to adhere to the provisions of this section that is documented by the department during monitoring may result in disciplinary action in accordance with this section. 6. Departments shall refer complaints alleging criminal activity that are made against the licensee to appropriate Oklahoma State or local law enforcement authorities. C. Disciplinary action may be taken against an applicant or licensee under this act for not adhering to the law pursuant to the terms, conditions, and guidelines set forth in this act. D. Disciplinary actions may include revocation, suspension, or denial of an application, licensee, or department approval, and other action. E. Disciplinary actions may be imposed upon an MMB licensee for 1. Failure to comply with or satisfy any provisions of this section, falsification or misrepresentation of any material or information submitted to the department. 2. Failing to allow or impeding a monitoring visit by authorized representatives of the department. 3. Failure to adhere to any acknowledgement, verification, or other representation made by the department. 4. Failure to submit or disclose information required by this section or otherwise requested by the department. 5. Failure to correct any violation of this section cited as a result of a review or audit of financial records and other materials. 6. Failure to comply with requested access by the department to the licensed premises or materials. 7. Failure to pay a required monetary penalty. 8. Diversion of medical marijuana or any medical marijuana product as determined by the department. 9. Threatening or harming a patient, a medical practitioner, or an employee of the department. And 10. Any other basis as identified in this section. Interesting, Raymond. I'll have to look into that. F. Disciplinary action against the licensee may include the imposition of monetary penalties which may be assessed by the department. G. Penalties for sales by an MMB to persons other than those allowed by law occurring within any 2-year time period may include an initial fine of $1,000 for a first violation and $5,000 for a second, for any subsequent. The MMB may be subject to a revocation of any license granted pursuant to this act upon a showing that the violation was willful and or grossly negligent. So if you're straight up running black market and you know it, you're going to get your license pulled. That's the whole idea with all this, is to help limit black market. That's why it's so important that people realize what they're getting into when they're opening businesses here. Because, guys, I mean, all of this, we're not even done. The amount of reporting that has to be done, and the amount of fines that could add up if you don't, not to mention losing your license. You know, this is all really legitimately put together, obviously. Okay, where was I? H, first offense for intentional and impermissible diversion of medical marijuana, concentrate, or products by a patient or caregiver to an unauthorized person shall not be punished under a criminal statute, but may be subject to a $500 fine. I, the second offense for impermissible diversion of medical marijuana, concentrate, or products by a patient or caregiver to an unauthorized person shall not be punished under a criminal statute, but may be subject to a $750 fine, and may result in revocation of their license upon a showing that the violation was willful and or grossly negligent. J, any patient or caregiver violating the permissible number of mature, immature plants allowed by this act may result in the following fines and possible loss of licensure. 1, possession of 1 to... Okay, so this is for patient and caregivers that are violating. Now we're not talking about commercial anymore. So 1, possession of 1 to 15 marijuana plants over the permissible limit may be subject to a $250 fine. That seems way more reasonable than what we've read in other proposals. 2, possession of more than 15 plants over the permissible limit may be subject to a $2,500 fine. Okay, I like that. That scale, that makes more sense, because, you know, you have to really try to get over 15, but to have 1 to 50, or, you know, 1 to even 10, not really difficult to accidentally do. But 1 to 15, you would actually, you know, depending on what your operation looks like. K, the following persons or entities may request a hearing to contest an action or proposed action of the department. 1, a licensee whose license has been summarily suspended or who has received a notice of contemplated action to suspend or revoke a license or take another disciplinary action. 2, a patient, caregiver, or temporary patient licensee whose license has been summarily suspended or has received a notice of contemplated action to suspend or revoke a license or take other disciplinary action. 3, an applicant for a license issued under this act whose application is denied for any reason other than the failure to submit a completed application or failure to meet a submittal requirement. 4, a person whose participation with an applicant or licensee is prohibited based on a criminal background check. Okay, L, the appellant, is that a typo, or is that a word I just don't know? I would assume that's applicant. Shall file the request for hearing. By the way, that's page 38 for anybody taking note of possible typos. Page 38, line 14, L. The applicant shall file the request for hearing within, or maybe it is appellant and I just don't know that word, 30 calendar days of the date the action is taken or the notice of contemplated action is received. The request shall be properly addressed to the department, state the time, address, and telephone number of the appellant, and 3, include a statement of the issue that the appellant considers relevant to the review of the action. Okay, all hearings held pursuant to this section shall be, 6 and 6, Raymond. But we're talking about over here in terms of penalties. M, all hearings held pursuant to this section shall be 1, conducted by a hearing officer appointed by the department. 2, conducted in Oklahoma City, Oklahoma, or with the consent of parties in other location. 3, due to federal and state confidentiality laws, hearings held pursuant to this section shall be closed to the public. Portions of hearings may further be closed to prevent the disclosure of confidential information. 4, the hearing shall be recorded on audio tape or other means of sound reproduction. 5, any hearing provided for in this section may be held telephonically with the consent of the parties. The department shall schedule and hold the hearing as soon as practicable. The department shall schedule and hold the hearing as soon as practical, but in no event later than 60 days, calendar date from the date the department receives a request for a hearing by the appellant. The hearing examiner shall extend the 60-day time period upon motion for good cause shown, or the parties may extend the 60-day time period for mutual agreement. The department shall issue notice of hearing, which shall include 1. A statement of the location, date, and time of the hearing. 2. A short and plain statement of the legal authority under which the hearing is to be held. And 3. A short and plain statement of the subject of the hearing. And Marcus, we're on page 39, about to read line 12. No, line 14. O. All parties shall be given the opportunity to respond, to present evidence, and argument on all relative issues. P. The record of the proceedings shall include the following. 1. All pleadings, motions, and intermediate rulings. 2. Evidence and briefs received or considered. 3. A statement of matters officially noticed. 4. Offers of proof, objections, and rulings thereon. 5. Proposed findings and conclusions. And 6. Any action recommended by the hearing examiner. Q. A party may request a copy of the audio recording of the proceedings. R. A party may be represented by a person licensed to practice law in Oklahoma, a non-lawyer representative, or may represent himself or herself. S. The rules of evidence, as applied in the courts, do not apply in these proceedings. Any relevant evidence shall be admitted. Irrelevant, immaterial, or unduly repetitious evidence may be excluded. 1. The experience, technical competence, and specialized knowledge of the hearing examiner, the department, of the staff of the department may be used in the evaluation of the evidence. 2. Failure of an appellant to appear at the hearing at the date and time noticed for all the hearings shall constitute a default. T. Unless the hearing examiner determines that a different procedure is appropriate, the hearing shall be conducted in accordance with the procedures set forth in this section. The following procedures shall apply. 1. The appellant shall present an opening statement, and the department may present an opening statement or reserve the statement until presentation of the case of the department. 2. After the opening statements, if made, the appellant shall present this case. 3. Upon the conclusion of the case of the appellant, the department shall present its case. 4. Upon conclusion of the case of the department, the appellant may present rebuttal evidence. And 5. After presentation of the evidence by the parties may present closing arguments. So a lot like a court setup, but not quite the same. U. The appellant shall bear the burden of establishing by a preponderance of the evidence that the decision made or proposed by the department should be reversed or modified. V. The hearing examiner may grant a continuance. For good cause shown, a motion to continue a hearing shall be made at least 10 calendar days before the hearing date, unless emergency circumstances arise. W. A party may request a telephonic hearing subject to the following provisions. 1. Any party requesting a telephonic hearing shall do so no less than 10 days prior to the date of the hearing. Notice of the telephonic hearing shall be given to all parties and shall include all necessary telephone numbers. 2. The appellant is responsible for ensuring the telephone number to the location of the appellant for the telephonic hearing is accurate and the appellant is available at said telephone number at the time the hearing is to commence. Failure to provide the correct telephone number or failure to be available at the commencement of the hearing shall be treated as a failure to appear and shall subject the appellant to a default judgment. Man, that would really suck if you're having service problems. I would say just get down there in person. 3. The in-person presence of some parties or witnesses at the hearing shall not prevent the participation of other parties or witnesses by telephone with prior approval of the hearing examiner. X. The parties may submit briefs including findings of fact and conclusions of law for consideration by the hearing examiner. Y. No later than 30 calendar days after the last submission by a party, the hearing examiner shall prepare and submit to the department or designee of the department a written recommendation of action to be taken by the department or designee of the department. The recommendation shall propose sustaining, modifying, or reversing the action or proposed action of the department. And Z. The department or designee of the department shall issue a final written decision accepting or rejecting the recommendation of the hearing examiner in whole or in part no later than 30 calendar days after receipt of the recommendation of the hearing examiner. The final decision shall identify the final action taken. Service of the final decision of the department or designee of the department shall be made upon the appellant by registered or certified mail. 1. The final decision or order shall be included in the file of the appellant with the medical marijuana program. And Section 9, page 41, line 24, line 25, Section 809 of Title 63. A. The department shall have the authority to issue declaratory orders by which a licensee may request the department to issue a formal statement of position and subsequently petition the department for a declaratory order. Typically, a position statement or declaratory order would address matters that are likely to be applicable to any other licensee. Any person, as defined in this act, may request the department to issue a statement of position concerning the applicability to the petitioner of any provision of the act and subsequent rules or any regulation of the department. C. The department will determine in its sound discretion whether to respond with a written statement of position following receipt of proper request. The department will respond by issuing a written statement of position or by declining to issue such a statement. D. Any person who has properly requested a statement of the position and who is dissatisfied with the department's response may petition the department for a declaratory order pursuant to this section. The petition shall be filed within 30 days of the department's response or may be filed at the time before the department's response if the department has not responded within 60 days of receiving a proper request for a statement of position and shall set forth the following: the name and address of the petitioner, whether the petitioner is licensed pursuant to this act, and if so, the type of license and address of the licensed premises. 3. Whether the petitioner is involved in any pending administrative hearings with the department or relative local jurisdictions. 4. The statute, rule, or order to which the petition relates. 5. A concise statement of all the facts necessary to show the nature of the controversy or the uncertainty as to the applicability to the petitioner of the statute, rule, or order to which the petition relates. 6. A concise statement of the legal authorities, if any, and such other reasons upon which petitioner relies. And 7. A concise statement of the declaratory order sought by the petitioner. E. The department will determine in its discretion without prior notice to the petitioner whether to entertain any petition. If the department decides it will not entertain a petition, it shall notify the petitioner in writing of its decision and the reasons for that decision. Any of the following grounds may be sufficient reason to refuse to entertain a petition. 1. The petitioner failed to properly request a statement of position from the department, or the petition for declaratory order was filed with the department more than 30 days after the department's response for the request for a statement of position. 2. A ruling on the petition will not terminate the controversy nor remove uncertainties concerning the applicability to petitioner of the statute, rule, or order in question. 3. The petition involves a subject, question, or issue that is relevant to a pending hearing before the state or any local licensing authority, an ongoing investigation conducted by the department, or a written complaint previously filed with the department. 4. The petition seeks a ruling on a moot or hypothetical question. 5. The petitioner has some other adequate legal remedy other than the action for declaratory relief, which will terminate the controversy or remove any uncertainty concerning applicability of the statute, rule, or order. F. The department may adopt a position statement as a final agency action subject to judicial review. If the department determines that it will entertain the petition for declaratory order, it shall so notify the petitioner within 30 days, and any of the following procedures may apply. 1. The department may expedite the matter by ruling on the basis of the facts and legal authority presented in the petition, or by requesting of the petitioner or the department to submit additional evidence and legal argument in writing. 2. In the event the department determines that an evidentiary hearing is necessary to a ruling on the petition, a hearing shall be conducted in accordance with the provisions of this Act and the Oklahoma Administrative Procedures Act. The petitioner will be identified as the respondent. 3. All the parties to any proceeding pursuant to this rule shall be the petitioner, respondent, and the department. Any other interested person may leave of the department to intervene in the proceeding, and such leave shall be granted if the department determines that such intervention will make unnecessary or separate petition for declaratory order by the interested person. 4. The declaratory order shall constitute a final agency order subject to judicial review. H. Files of all requests, petitions, statements, or of positions and declaratory orders will be maintained by the department, except with respect to any material required by law to be kept confidential. Such files shall be available for public inspection, with the exception, okay. I. The department shall post a copy of all statements of position and all declaratory orders on the department's website. I really hope that's the last time I have to read the word declaratory. Section 10, we're on page 44, line 16, 17, 18. Section 10, section 8010 of Title 63. A. Those license applicants and license holders subject to the requirements of this Act may request that a variance be granted from the requirements of this Act. Such variance shall only be granted or the term of the current license period or less. Well, that's interesting. What variances? B. A variance request filed in conjunction with an application for license or renewal of license shall extend the time allowed for the review of the application for license or renewal of license. Variants requested pursuant to this section are subject to approval by the department. In order to have the variance approved, an applicant or license holder must submit a written application on a form provided by the department. D. Variances may be reviewed and reconsidered for each successive licensing period. Prior to the expiration of the current license, the licensee must apply in writing for renewal of the variance on a form provided by the department. The process for approval of the renewal is the same as the process for granting the original variance. Each renewal shall be considered a new, separate variance and must be independently justified. E. Any applicant or licensee requesting a variance shall apply in writing. No, a form. Okay, that's a typo and I can't figure out what it's supposed to say. An applicant or licensee requesting a variance shall apply in writing or a form provided by the department. I think that's what to say. It says writing no a form, which doesn't make sense. So I would assume that that's a typo. Page 45, line 5, in writing no. Okay, moving on. The form shall include 1. Information sufficient to the reference any pending application for license or existing license. 2. The section of this Act for which the variance is requested. 3. Reasons for requesting a variance. What up, Giddy? 4. The specific variance requested. 5. Any documentation which supports the application for variance. F. In consideration of this request for variance, the department shall consider the following: 1. Compliance with the Act. 2. The impact of the variance on public health and safety. 3. The creation or avoidance of public nuisance. And 4. Alternate policies and procedures proposed. G. If the department finds that a request is incomplete, the department shall advise the applicant in writing and offer the opportunity to submit additional or clarifying information. The applicant shall have 30 calendar days after receipt of notification to submit additional or clarifying info in writing to the department, or the request shall be considered withdrawn. H. The department shall permit or disallow the variance request in writing in 45 calendar days after receipt of the request. I. Variances are not a part of the license. Denial of a variance is not subject to appeal. A variance may be revoked upon finding the licensee is operating in violation of the variance. The licensee shall be entitled to a hearing prior to revocation. Okay, Giddy, if you're still on here, man, I know I saw you just pop back on. Tell me about this, Section 10, 8010, Title 63, variances. Like, what would a variance be considered? Trying to get maybe a location that is not normally in the Act, or not something we're supposed to do, like, say, closer than 1,000 feet to a school or something? Or are we talking a variant like in, what exactly is that referring to? What variance? Obviously this was put in here for some exceptions to be made in certain areas. What would you say that would be? Am I going in and out on my internet? It's not showing that I am. Anyway, if you caught that, Jason, you can respond below or whatnot. Anything. Yeah, anything. So basically, this is a section that allows for the rules to be to be changed for exceptions in their business. I like that. I think that's good. I mean, I like the fact that they have to go through the department to do that, but I like that. Okay. Section 11, new law. We're on page 46, line 4. Section 8011 of Title 63. A. The Department shall create and maintain a medical marijuana use registry for physicians, patients, and caregivers as provided under this section. The handling of any records maintained in this registry shall be compliant with the HIPAA privacy rules. B. The medical marijuana use registry shall, 1. Be accessible to Oklahoma qualified physicians and medical marijuana dispensaries to verify the authorization of a qualified patient or caregiver to possess medical marijuana or medical marijuana products. So this is the registry for physicians and patients. So 2, be accessible to licensed physicians to ensure proper care for patients before medications that may interact with the medical use of marijuana are prescribed. I've asked this question before, guys. Can somebody post to me a list of medications that react with marijuana that we know of? I'm sure there's actually some out there, but I've never seen any posted, and I would love to see that if somebody wants to drop that below or make a post about it and tag me in it. 3, prevent an active registration of a patient by multiple physicians. What does that mean? Trying to get multiple cards? C, the department may contract with a third-party vendor to provide this service. Oh, I'm sorry. This is, we're talking about commercial again. Department may contract with a third-party vendor to provide this service. The vendor selected by the department may have experience performing similar functions for other state agencies and may not contract with anyone providing commercial services to an MMB either directly through affiliates or indirectly through any joint venture or subsidiary. D, all other records regarding a medical marijuana licensee shall be maintained by the department and shall be deemed confidential, and the handling of any records maintained must be compliant with the HIPAA privacy rules. Such records shall be marked as confidential, shall not be made available to the public, and shall only be made available to the licensee, designee of the licensee, the physician of the licensee, or the caregiver of the licensee. No personally identifiable information as defined under the HIPAA privacy rule may be stored at the department. E. A log shall be kept with the file of the licensee to record or to record any events in which the records of the licensee were made available and to whom the records were provided. F. The department shall ensure that all application records and information are sealed to protect the identity of medical marijuana patient licensee license applicants. G. The department shall make available a method to validate the authenticity of medical marijuana patient licensee by a unique 24-character identification number as follows. 1. The department may either itself or by contract with a third-party vendor or government entity to provide an automated programming interface database which is updated in real time and will verify the authenticity of medical marijuana license, unique 24-character identifier as a point of Hey, look, I'm back. This is it. This is it, man. I'm telling you, I made it 50 minutes this time, but boom, lost network connection. This time for over a minute. I'm not getting spam this time. No, not anymore. This isn't phone calls. This is internet connection. My actual network connection to Verizon cut off. Completely lost. I am looking at the phone. Oh, you guys still are still talking about when it was freaking low network connection. It did it to me again, guys. At least I got quite a bit of the ways through this time, so I'm gonna have to try this all over again. So I'm gonna end this one. We got quite a bit covered this time. Remember, guys, we're at the bottom of page 47, section 12, 8012, title 63. So when I hop back on, we'll start there. I don't know when we're ever gonna fucking finish this if it keeps cutting in and out on me like this. All right, guys, peace. I will come back. See you then.